Many potential clients call our office to inquire about mediation. Mediation can take many different forms. Most often, parties hire an attorney to assist them through the divorce process, including getting a resolution on custody, child support, dividing up property and debt, and alimony issues. Sometimes one of the parties will file a lawsuit to try to get these issues resolved with the assistance of a judge. Other times, the parties will try to negotiate a settlement. The parties can at any time try to mediate the issues and come to a resolution without having to go to a trial. In North Carolina, some issues such as equitable distribution and child custody must be taken in front of a mediator before the court will set a matter for trial. The hope is that people can come to a resolution on their own without involving the court. Some issues such as child support and alimony do not have to be mediated prior to a judge having a trial on the matter. When parties have hired lawyers, the parties and the attorneys can agree to hire a mediator. The mediator can be an attorney or a non-attorney who has been trained to be a mediator. The mediator's job during the mediation is to get the parties to come to an agreement. Each party's lawyer represents their client's interest, and the lawyers help the parties understand their rights and what might happen if they don't settle and instead end up in a trial. There are pros and cons to mediation. Some cons are, number one, the process can take all day. People that have not been to mediation often do not understand how long the process takes. The mediator will start out by laying out the ground rules. Then the mediator will go into a room with one party and that party's attorney. They will discuss the case and the reasons that party thinks they should have a certain outcome. The first party will then make an offer. The mediator then goes to a different room with the second party and his or her attorney. The mediator will tell the second party what the offer was, and then the second party will tell the mediator his or her side of the matter and make a counteroffer. The mediator goes back and forth until there is either a settlement or an impasse. The second con to mediation is that most everyone that settles at mediation feels like they've lost. Both parties have to give up things they wanted during the course of the mediation in order to get a case settled. Therefore, almost no one is happy when they leave a mediation. The third con to mediation is that mediations are expensive. The parties pay for the time their lawyer is at the mediation, and they usually split the cost of the mediator. A mediation can cost several $1,000s. The pros of mediation are, number one, when the case settles, both parties can move on with their lives. Number two, mediation is much cheaper than a trial. Mediation might cost several $1,000s, but a trial can cost upwards of $10,000. The parties decide what happens to their lives instead of allowing a judge to make decisions for their family. If you are interested in having an attorney represent you at mediation, or if you need a mediator to assist you in a mediation, contact Stallard and Bellof. We have attorneys that are skilled at representing clients in mediation, and we also have attorneys that are certified mediators.